Alright, so my poster is on the debate over the Bill of Rights. Basically, it was like this is the founding document with the first 10 amendments after the Constitution. So like the Anti-Federalists wanted it, but the Federalists didn't want it. And the Anti-Federalists argued that like without a Bill of Rights there would be tyranny. Like they also argued that many other countries had bills of rights, and they wanted a clear statement of what the government couldn't do. And the Federalists argued that like it was unnecessary, and it might imply that not explicitly mentioned rights are not protected, and the Constitution is good enough already. So before the Bill of Rights was proposed, 6 out of the 13 colonies wanted to ratify the Constitution, and 7 of them didn't want to. But like for the Constitution to be ratified, all 13 of them had to like agree to ratify it. So the timeline for the Bill of Rights, the Articles of Confederation, in like 1779, I think. Constitution drafted after that. Then the ratification debate of the Constitution. 9 states ratified. Then the Bill of Rights proposed because it was because the votes weren't like unanimous. And then the Bill of Rights was ratified, and then the Constitution was like put in place. And the list of the Bill of Rights amendments were the first one was like the freedoms of speech, freedom of religion, freedom of the press, freedom of petition, and freedom and the other freedom. And the second one was the right to bear arms. The second one was the right to bear arms. Right to bear arms. And that meant like you could have like guns and stuff, and the government couldn't take them away from you. The third one was no quartering of soldiers, and like a soldier couldn't go to your house like during a war and tell you that like they need to sleep in your house and you have to feed them and stuff. Like you couldn't do that anymore. The fourth one was search and arrest. So there was no like unreasonable searches, and to search like someone's property you needed a warrant. The fifth one was rights in criminal cases. Like if you hear anyone in court say, "I plead the fifth," that means that that means that they're referring to the Fifth Amendment, which was like they can't like the court can't force you to say something that might incriminate yourself. The sixth one is right to a fair trial. Like it's a speedy trial. Like it can't take very long. And the seventh one was rights in civil cases. The eighth one was bail, fines, and punishment. So the bail can't be like an unreasonable price, like $1 million for bail. And the Ninth Amendment was rights retained by the people, and the 10th one was states' rights, which meant that anything that wasn't like explicitly mentioned in the Constitution was up to the states, and like they decided like what's going to go on with that.
This is living constitution versus originalism. What is a living constitution? A living constitution is the idea where the Constitution and how it was written originally should be changed over time to fit current situations. An example of this could be some machinery and yeah. What are the benefits of a living constitution? It is evolved to best help ongoing conflicts, and it includes problems that the founding fathers may have not realized were problems. What are the cons to a living constitution? It could allow people in power to interpret the rules of the Constitution differently than how it was originally stated. What is originalism? Originalism is a belief where the Constitution should say exactly how it was written when authors created it. And it shows the meanings and intentions of that time. What are the benefits to originalism? It makes the Constitution more stable. It's intended to force judges to follow the Constitution instead of their own beliefs. The cons to originalism. It could lead to outcomes that are ignorant of people's rights. And is the Constitution outdated? The text in the Constitution might not exactly be as relevant today than it was when it was written. My opinion, I think that we should come up with a compromise that would keep the Constitution as it is, but preserve it. We could create not necessarily a new government, but make it more evolved. The government could be something that everyone agrees upon and everyone benefits from it. It could protect the people, but keeping the Constitution alive. Some examples could include the amendment process, which is used to help evolve the Constitution and better fit like different situations. Prevention of tyranny, maybe making the government even more spread out of power. Inclusion, including everyone and like helping make sure like the rules apply to everyone, but also giving people a lot of freedom. And forward progression, having instead of being like stuck on what the Constitution was, maybe make it what it is now. We can't erase the history, but we can build from it. How are amendments made? An amendment is proposed by the House and Senate by a 2/3 vote. To ratify this amendment, it must be approved by 3/4 of the state legislators. There are so many amendments that are proposed that are not ratified. The Founding Fathers purposely made it incredibly difficult to pass amendments so that the majority of the people would agree to them. They did not want bad amendments to be passed to potentially harm a ton of people. Amendments are an example of a kind of living document because we are changing the Constitution for the better possible. So that leads me to, wait, I messed up, never mind. Then,
Okay, this is my game, Constitution Crisis. Have you heard of the Constitutional Crisis? Well, the Constitutional Crisis is an ongoing debate about whether we should dissolve the Constitution or not. There are two sides to this debate. Yes, we should, and no, we should not. Thomas Jefferson believed the Constitution should be rewritten every 20 years, and he makes a good point. What could happen 240 years ago still apply what's happening now. But a lot of Americans worship the Constitution and don't want it to change. People worship the Constitution because it's a document that gives American citizens their rights. For example, the Constitution gives us our freedom. So what if the Constitution is rewritten? What is that going to look like? These are all good reasons, but the main reason people want to dissolve the Constitution is so that they can make it easier to change. This might seem crazy, but the Constitution is extremely hard to change, and there are two ways to do it. To amend the Constitution, you either have to have 2/3 of Congress to vote for the new amendment, or you can get 3/4 of the states, which is 38 states, to agree on the amendment. So this is my game, and so there's two roads. This road is the Congress, so you're gonna start on this road, and to play, you get like a bunch of trivia cards, and these are like trivia about the Constitution. Some are also from the U.S. citizenship test, and then you get a dice, this one, and it's like a hexagon with dice, and it has negative and positive numbers, and then you get 2 tokens, so the yes and the no token. So you need at least 2 people to play this game. So each person chooses a team, and the teams don't need to be even, so if you have like 5 people, they don't need to be even. So you're going to choose if you want the Constitution to be solved or not, and then you're going to put your tokens on your first road with the Congress, and you're going to get asked one of these like trivia questions. So this one is, who is in charge of the executive branch, and it's multiple choice, and on the back it gives you your answer and a little bit about it. So then if you get the question right, you get to roll the dice and you can move along the path. But your goal is to land exactly on your 2/3 marker. And if you make it to the end of the road before landing on this marker, you have to restart on road 2, where you have to land on the 3/4 marker. More rules are like, you're on the dice, there's this like black part, and that's a blocker. So you can take one of these tokens and you can like block someone's path and they have to stop, but you can't do that in the safety zones. And then if you go to road 2 and you're like not doing very well and you get to the end of this road as well, before hitting the exactly on the 3/4 mark, you have to get one of your previous questions right to continue the game, and then you get to start back at the midpoint and keep going. So, yeah. And then also the game comes with like this rule book, and inside it has a lot of like background information, 2 sides, and then it also explains all the rules that you need. And in the back, it gives you facts and charts about like anything. So, yeah, that's like every turn sponsors. Oh. Okay, so you have a 3. So you got a 3. So you get to move on this road, the first road. 2. Yeah. Okay, it's your turn.
Alright.
Okay. Right. What is an amendment? A right, a right in the Constitution, a change to the Constitution, a rule in the Constitution, or a book?
This one.
B. A change. Yeah, that's right. Okay, you can roll, and nothing can be negative. I'll reread this. What is not one of the rights of our amendment? A. The right to bear arms. C. Religion, or D. Speech. You don't get B. Is that your answer?
The first one. Wait. The First Amendment?
Yeah.
Yeah, then the first one.
Okay, yeah. Nice.
Yeah, I'll roll it. This is quite a beautiful dice.
4. Oh wait, no, you didn't get lucky. Okay, so now they're in the safety zone, so you guys can't block them.
Alright.
Okay.
First.
Oh,
-3. Oh boy.
Okay.
Roe v. Wade by Ellie.
And Isla.
So Roe v. Wade. So first of all, we'll talk about Jane Roe. So it started with Norma McCorvey, a woman who was pregnant in 1971 when the case in Texas happened. McCorvey and the people she worked with used the fake name Jane Roe. Roe argued that abortion was unconstitutional.
The other side in the case was Wade. Henry Wade was the district attorney of Dallas County in Texas. He defended the law that banned state abortions in Texas. So what was it? Roe v. Wade was a Supreme Court case that decided that women had a constitutional right to choose to have an abortion. It made abortion legal nationwide for 50 years until it was overturned by the Dobbs v. Jackson case in 2022.
Okay, so here's just a timeline of the events. So it first started in 1971 when the case was first argued.
The case was re-argued in Texas in 1972.
Then in 1973, Roe v. Wade decided.
In 2021, the Dobbs v. Jackson case was heard.
And in 2022, Dobbs overruled Roe.
And then this is a map of abortion legality in the contiguous USA. So the red is abortion is banned, the green is legal and funded by a state, and the yellow is the state follows restrictions.
And some facts about the case are that, so the 2 lawyers that represented Jane Roe were only 26 years old in 1971, which is very young for 2 lawyers. Jane Roe won the case with the final ruling of 7-2, and Jane Roe was 22 when the case was filed, but Henry Wade was 56 years old. Hi everyone, and welcome to the first episode of the Roe Report.
Where we talk about all things Roe v. Wade.
I'm your host, Ellie.
And I'm Isla.
Now let's get started.
Welcome to the Roe Report.
Where the rights and facts and truths come forth.
We're Ellie
And Isla.
We're breaking it down. Supreme Court cases.
Let's choke the down.
So Isla, what is Roe v. Wade?
Roe v. Wade was a Supreme Court case that decided that women had a constitutional right to choose to have an abortion. It made abortion legal nationwide for 50 years until it was overturned in 2022 by Dobbs v. Jackson. which we will get to in a future episode. So Ellie, where did it start?
Roe v. Wade started in Texas in 1970 when a woman named Norma McCorvey, who used that fake name Jane Roe, sued Henry Wade, the district attorney of Dallas County, because she wanted to challenge the Texas law that made abortion illegal except to save a woman's life. So what led up to the 1971 court case in Texas?
Norma McCorvey, also known as Jane Roe, was pregnant and wanted an abortion but couldn't get one legally in Texas. Two lawyers named Sarah Weddington and Linda Coffey decided to represent her and challenge the state law. Before that, though, most states had laws that banned or severely restricted abortion, forcing many women to seek unsafe and illegal procedures. So Ellie, who's involved in the original case?
As you said, the main people involved were Norma McCorvey, who was Jane Roe, who wanted an abortion in Texas and challenged the law, and Henry Wade, who was a district attorney of Dallas County, Texas. He defended the state law that banned abortions. Some other important people are Sarah Weddington and Linda Coffey, who were the two lawyers who represented Jane Roe and argued that with the Texas abortion law, it was unconstitutional. Now, none of this would have happened without the U.S. Supreme Court justices, especially Justice Harry Blackmun, who wrote the court's majority opinion in 1973, explaining that the right to privacy protected a woman's right to choose. What do the years 1971 and 1972 have to do with the actual Roe v. Wade case in 1973?
In 1971, the case first went to the U.S. Supreme Court after Jane Roe's side appealed the lower court's ruling. The Supreme Court heard arguments that year, but didn't decide yet because two new justices had joined the court. In 1972, the case was argued again so all the justices could hear it. Then in January 1973, the Supreme Court announced its final decision, ruling 7-2 in favor of Jane Roe.
Thank you so much for watching the Roe Report, and we'll see you in the next episode where we talk about the 1973 court case. Bye!
Hi everyone, and welcome back to the Roe Report. I'm Isla.
And I'm Ellie.
In the last episode, we talked about what led up to the case. In this episode, our topic is the 1973 Supreme Court case.
Welcome to the Roe Report,
Where the rights and facts and truths come forth.
where Ellie
And Isla,
we're breaking it down. Supreme Court cases.
that took the down.
So, what was the Roe v. Wade case?
So the Roe v. Wade case was a Supreme Court case that was passed in 1973, making it legal to have an abortion in the U.S. It lasted 50 years and judged that having an abortion was a constitutional right for women. So Isla, what were the sides?
The winning side was Norma McCorvey, also known as Jane Roe. Roe was guided by others, including a 20-year-old woman named Sandra Benson. McCorvey was a young woman with 3 kids at the time. She had challenged criminal abortion laws in Texas, claiming that she had been raped, until the case made its way to the Supreme Court. The opposing side was Henry Wade, a district attorney for Dallas in Texas. How did the case connect to the 14th Amendment, and why was it brought up in the case?
So during the case, Roe argued that abortion law was unconstitutional because it went against the 14th Amendment. Violet, what even is the 14th Amendment?
The 14th Amendment granted birthright citizenship and guaranteed all citizens equal protection of the laws. It prohibited states from depriving any person life, liberty, or property without due process of the law. So, what did that mean for them?
So they argued that abortion was a human right protected by the 14th Amendment because they believed that abortion fell under the category of the right to personal privacy, allowing a woman to choose what to do with her body and baby.
The Supreme Court agreed, until 50 years later in the Dobbs v. Jackson case, which we will get to next episode.
Thanks so much for watching the Roe Report, and we have a special surprise next episode, so stay tuned. Bye! Hi everyone, and welcome back to the Roe Report. I'm your host Ellie,
And I'm Isla.
In the last episodes we talked about what led up to the original Roe v. Wade case, and then the actual case itself, spanning from 1970 to 1973. Today, we're talking about the Dobbs v. Jackson case in 2021 and 2022. To talk about that with us, we have expert Bryce Perkins.
Welcome to the Roe Report,
where the rights and facts and truths come forth.
We're Ellie
And Isla,
we're breaking it down. Supreme Court cases
that shook the town.
Hey, come on over.
Come on over.
Hi guys, thank you for having me.
Thank you for coming.
Okay, so Rex, we have a few questions. So, what was the actual Dawes v. Jackson case?
It was a big Supreme Court case in 2022 about a Mississippi law that banned most abortions after 15 weeks. The court used this case to change how abortion laws worked in the U.S.
But how is that different from other abortion cases?
So instead of just changing some rules, this case let states fully decide their own abortion laws. Some banned it and some didn't.
So, what effect did it have on America?
It changed a lot of things. In some states, abortion became illegal or harder to get. It also led to protests, court fights, and made abortion a huge issue in politics.
Why do you think that the court decided differently this time?
Well, the judges on the court had changed. More conservative judges were added, and they saw the issue differently than the judges before them.
What led up to the Dawes v. Jackson case after almost 50 years of just no
Changes.
Yeah.
For years, some states made stricter abortion laws and tried to change the old rules. Mississippi's law finally gave the court a chance, like they were ready to take on.
Thank you so much for coming.
Thank you.
Bye.
Bye. We'll see you next time on the Row Report. Back in Texas in '73, a woman said,
Hey, what about me?
Norma Rowe was her fake ID.
But she brought a case to make folks see.
She wanted a choice, she wanted rights. To fight the law, she lit the lights.
With lawyers bold and voices loud, they took her case above the crowd.
Roe v. Wade made the news.
Talking about the right to choose.
Court said yes, but the law was wide.
It's about the right to decide.
Roe v. Wade changed the game.
Now everybody knew her name.
From court to crowd, the fight was loud.
A woman's right was lawfully proud.
Wade was the man who said
No way.
he tried to keep Roe's rights at bay.
They went up to the highest floor. The Supreme Court opened up the door.
They ruled with 9, the vote was 7-2. They said
Constitution's got your back too.
privacy's found in the 14th scene.
Illegal, right? If you know what I mean.
Roe v. Wade made the news.
Talking about the right to choose.
Trimester laws were set in place.
But each one moved at its own pace.
Roe v. Wade, bold and bright.
Brought the choice into the light.
From silent cries to legal highs.
The ruling echoed through the skies.
Yo, it wasn't law, it was history. Shaped the world for you and me. Boots and caps and boots and claps and boots and caps and boots and caps. The laws can flip and the rules can bend. In 2022, it met its end. Boots and caps and boots and caps and boots and caps and boots and caps. Roe v. Wade, we still remember. Like a flame that burns in every ember.
Though it's gone, the voice survives.
In courts, in hearts, in people's lives. So tell the tale, or keep it alive.
Of Roe v. Wade, the right to strive.
From then till now, we still decide. The power lies in the people's side.
Okay, real quick, here's what went down. There used to be a national right to abortion in the U.S. because of a Supreme Court case called Roe v. Wade. That meant all states had to allow it, at least in the early weeks of pregnancy. But in 2022, the Supreme Court looked at a new case, Dobbs versus Jackson's Women's Health Organization, and said, yeah, we're done making the decision. States, y'all figured out. And then everything kind of went nuts. Okay, everybody, chill.
We're growing carrots.
Stop. The Supreme Court just dropped the Dobbs decision, and it's a whole thing. Let's go around and say what everyone's doing.
I'll start. This was my case anyways. I told the court, let me make my own rules, and they were like, sure, go for it. So I did. No more abortions here.
That's fine. We're still doing it over here. Clinics are open, people are safe, everything's chill.
Same but opposite. We banned it, people seemed fine with it, so moving on.
Yeah, well, I've got people flooding in from all over. My hospitals are packed. We're helping, but it's crazy out here.
We are not messing around. Doctors, patients, we got your back. no one's getting in trouble here.
Man, I'm stuck. Half my people want one thing, the other half want the opposite. No matter what I do, someone's mad at me.
So we voted, thought we'd ban it, but surprise, people wanted to keep it legal. Honestly didn't see that coming. Y'all keep switching things up on me.
Some of us teamed up. If your state bans it, we'll help people get care anyway. We're trying to help out.
My laws change like every 5 minutes. One day it's banned, the next day it's not. I can't even keep track anymore.
Y'all could call it ban. I call it protecting life. That's what matters to me.
We just said, let people choose for themselves. So we made that law. Boom! Done.
So everyone's kind of doing their own thing now, huh? Cool. Just 50 different answers to the same question.
It's a mess. Doctors don't know what's legal, patients are driving hours for care, and my lawyers are losing their minds.
This isn't just about laws. It's about who we are, what we believe. This stuff matters, you know?
Exactly. That's why we should decide, not some fancy judges off in D.C.
Maybe, but people shouldn't lose their rights just because they live in a different state.
Well, at least we all agree on one thing, that we really don't agree on much. Alright, here's where we're at now. It's been a minute since the Dobbs decision, and yeah, things are still all over the place. Some states double down on bans, others pass new laws to protect access. People are crossing borders just to get health care. Clinics are opening in some places and shutting down in others. Lawyers are busy, courts are busier. It's like every state is writing its own rule book, and nobody's getting the same version. People are still fighting, still voting, still yelling, but everyone is still hopeful that their voice is heard.
This is one of the United States cases, Marbury versus Madison, who can declare laws unconstitutional. Notes, 1800 to 1803. These are just notes. Thomas Jefferson defeated John Adams in 1800 for president. Jefferson passed the Judiciary Act before he stepped in office. The Judiciary Act gave the president more control over appointment of judges, added judges, and created new courts. The appointees were appointed by the Senate, but they wouldn't be allowed to do anything without the approval of the Secretary of State. William Marbury was appointed the Justice of the PDC, Peace in the District of Columbia, but his resignation didn't arrive. Marbury wanted the Supreme Court to ask Madison to deliver the documents, his resignation. The court declared Section 13 of the Judiciary Act of 1789 null and void. The courts found that James Madison's refusal to deliver the papers was illegal. James Madison was the Secretary of State. Surprisingly, Madison was not ordered to give Marbury the, can't see that, but it says admission for Marbury. Notes, 1803. James Madison, Alexander Hamilton, and John Jay took a full year, 1787 to 1788, to write an issue that defended the Constitution, the Federalist Papers. Marshall believed that the Supreme Court should have a say in the current government. Congress believed that the opposite of the Marshall's point of view. The court held that the settlement of the Judiciary Act of 1789, letting Marbury bring his claim to the Supreme Court, was itself unconstitutional, since it alleged the court's original legal decisions beyond that. Article 3, Section 2 was established. Congress didn't have the power to modify the Constitution. John Marshall passed a law saying that the judicial branch can declare laws unconstitutional. Chief Justice John Marshall established the law, checks and balances, which made every branch of government, executive, legislative, and judicial, power and weakness over one another, so not one could become too powerful. Notes, statement. In the early days of the United States, it was unclear which branch of government had the final say in what is and is not a constitutional law. There was even some questions of whether a federal law could still be enforced if it did violate the Constitution. If the case Marbury v. Madison resolved the question of judicial review and expanded the role of the Supreme Court. Fun fact: a cool word was passed in 1783, meaning a court order making a government official, a lower court, or a government entity doing something that they are legally required to do. That makes me laugh so much. Mandamus. And the United States of America.
So this is our poster on Korematsu versus the United States, and we have a timeline and some fun facts. So it started in 1942 when Roosevelt signed Executive Order 9066, which basically made all Japanese Americans from Washington to Arizona to be moved to relocation camps. And then in 1942, in May, Fred Korematsu was arrested by the FBI after refusing not to go to these camps. And then in 1942, in September, he was tried in court in San Francisco, and he wasn't happy with the results, so he went to Supreme Court in 1944, and they declined his case, and he was arrested and he stayed in jail for 5 years. And then in 1946, in June, the Relocation Authority was finally banned.
In 1998, President Clinton awarded Korematsu with the Medal of Freedom. In 2005, Fred Korematsu died. In 2011, California established Fred Korematsu Day.
And then some fun facts.
During 9/11 attacks, Korematsu spoke out for the discrimination of Muslim Americans.
And then Clyde Sarah, which is what Korematsu changed his name to so he wouldn't be found by the FBI. It was his girlfriend's middle name.
And this is the Japanese flag, and this is the American flag.
This is our poster on Jefferson versus Adams. So first, Thomas Jefferson was born in 1743 on April 13th. He was the author of the Declaration of Independence. He was a founding father. He was the governor of Virginia in 1979. He was a gifted writer at 33. He resigned from the Continental Congress. He was reelected to the Virginia House of Delegates. He was 6'2". He was the U.S. Prime Minister to France. He didn't attend the Constitutional Convention. He advocated for presidential term limits in the Bill of Rights, and he died on July 4th, 1825, less than 5 hours before John Adams did. And that was also the 50th anniversary of the Declaration of Independence. John Adams, he was born in 1735, Massachusetts Bay Colony. He went to college at 16, and in 1797 to 1801, he was the leader of the American Revolution. He was second president. He strongly did not want the war to break out. He did not call for the declaration of the war. Adams' urging was making the war worse and worse. He died July 4th, 1826. His last words were, "Thomas Jefferson survives." And then in our Venn diagram, we have Thomas Jefferson was the third president from 1801 to 1809. He was the vice president to John Adams in 1797 to 1800. He was from Virginia, and he was an anti-federalist. And both of them, they both wrote the Declaration of Independence. They were both vice presidents and presidents. They were both foreign secretaries. They both died on July 4th, 1862, and they were both founding fathers.
And Adams was the second president in 1796 to the 1800s, and he was vice president to Washington 1789 to 1797, and he was born in Massachusetts, and he was a Federalist.
And then both of them they met in 1775 as delegates to the Continental Congress.
As vice president, Jefferson didn't agree with Adams' next election, ran against him.
In the 1800 election, Thomas Jefferson and Aaron Burr tied, but Jefferson ended up winning.
Thomas Jefferson had doubts for running for president, so he ran for the vice president.
They were friends, and then they turned against each other when they were presidents, but then they came back as friends and died as friends.
They died within 5 hours of each other.
Okay, I did George Washington and how he played a big role in the Constitutional Convention. And some of the ways he did that was he was very quiet, and instead of debating with people, he kind of worked behind the scenes. And he was very well respected and had good leadership skills even before that. And he really wanted difference, and he gained military experience prior to that. And a lot of people believed in him, like Benjamin Franklin, and that paid off a lot because then he was president after. And some fun facts and early life details about him is that he was born February 22nd, 1932 in Virginia, and he died December 14th, 1999, also in Virginia. And he was an American general and commander-in-chief of the colonial armies in a war. And when he was younger, he worked in a farm a lot, on his family farm, and he grew tobacco. And then he was the longest and first president, and he was often called the father of his country. And yeah.
Alright, this is the Insurrection Act by me. What is the Insurrection Act? The Insurrection Act is a law that lets the president send the U.S. military to keep order inside the country. It is used if there is violence, rebellion, or major unrest and the state can't control it on its own. How has it affected our country? It gives the president a way to restore peace and safety when big problems like riots go out of control. It helps the federal government protect people's rights when the state or local leaders can't. It's a powerful tool that can keep order, but must be careful so it doesn't harm democracy. Fun facts. The law allows the president to use the military inside the U.S., which is rare for the American laws. It's only been used a few times in more than 200 years. The Civil Rights Movement and the Los Angeles riots are 2 times it was used. People still debate whether it gives the president too much power. What is our current president doing about it? The current president has talked a lot about using the Insurrection Act, but has not officially done it. He says if he would use it if there was major riots or danger that local leaders could not control, like Chicago. In Chicago, there are a lot of riots and crime rates, which President Trump says that he should send in troops so crime rates go down. And he's already sent troops in Washington, which have, he says, made Washington and Los Angeles a lot better for crime and lower death rates. Some people support his actions to keep order, while others worry it gives President Trump too much power. Thank you.
Okay, this is our poster on the 14th Amendment. What is the 14th Amendment? The 14th Amendment is an amendment that grants everyone born or naturalized in the United States citizenship.
How did it affect our country? It protected all citizens born or former slaves. It gave everyone equal protection under the laws with like no exceptions. It made the states follow the Bill of Rights and helped expand the civil rights and freedom. Two things that connected to it were the Due Process Clause, which was part of the U.S. Constitution, and it made it so that the government cannot take away any person's life, liberty, or property without the proper fair legal procedures. And then a Supreme Court ruling that was an example of like what went wrong was the Dred Scott decision in 1857, and he was an enslaved African American who was in a free state, and the Supreme Court ruled against him, and it made civil war more likely to happen because it allowed slavery to spread out more throughout the U.S. and is known as one of the worst Supreme Court rulings in the U.S.
The 14th Amendment has 5 sections. Section 1 talks about that no state is allowed to go against the amendment. Every person born or naturalized in the U.S. is protected by it.
Section 2, if a state denies male citizens over 21 the right to vote, that state will lose a number of representatives in Congress unless a crime rebellion was committed.
Section 3 is anyone who was sworn an oath to the Constitution but ends up insurrection or rebellion cannot hold any federal or state office, and Congress can rule with 2 out of 3 vote in each house.
Section 4, all U.S. public debt is reasonable and can't be questioned. The U.S. state will never pay back any debt that was related to Confederacy's rebellion, and the U.S. government is not reasonable for former slave owners' financial problems. So if they can't have their slave anymore, then they can't get paid back for it.
And the 5th section, the final section, Congress is allowed to make laws to make sure this amendment is followed.